This is a recording for my professional responsibility course. And in this brief video, we're going to talk about some sort of big picture issues with the ABA's model rules of professional conduct. In my course, we're going to be studying the model rules in depth, one kind of going through them in order of how heavily tested they are on the MPRE exam. But first, let's take a moment to talk about some of the sort of big picture issues to watch for as we're going through the model rules. And so first, let's talk a little bit about the structure of the rules. There's a definition section at the beginning that we don't really usually cover in a course, and most of these are obvious, but a few, especially the definition of knowledge and knowingly, are terms of art and are important for interpreting some of the substantive rules. The main thing you need to know about the definition section is in some of the comments to the model rules, it will refer back to see section 1.0 or the definition in section 1.0, and you can flip back to that and see sort of the technical definition. But again, most of the definitions are kind of what you would expect. The rules are grouped into kind of topical groups, and then the numbering follows that grouping. And this can help you if you want to remember the numbers of the rules. And so we have a group that's all of the rules about client-lawyer relationships, so everything from conflicts of interest to who makes which decisions to withdrawing from representation and things like fees. We have, and all of those rules start with the number 1. So it's 1.2, 1.3, 1.4, and so forth. And then we have a section, the second section is lawyers, counselor. This is a very short section that are rules pertaining to things that a lot of law students might not think of as traditional legal representation, like just being brought in almost as a consultant or to do an audit of someone's business, a legal audit or something like that. And so those 3 rules start with the number 2. Advocacy and litigation. This is a big set of rules that all start with 3.1 to 3.9, that relates to a lawyer's duty in litigation. So things like candor to the tribunal or being honest with the judge, rules about your interactions with jurors or the opposing counsel and the opposing party, or destruction of evidence and frivolous claims and so forth. Those are all there. The fourth group is interacting with people that aren't your clients, so unrepresented other parties, witnesses, and things like that. The fifth group, the rules that start with number 5, all relate to the special ethical issues that come up when lawyers organize into law firms or law offices. So for example, when are supervisors responsible for ethical violations by their subordinates? And who can have an ownership share or invest in a law firm? And concerns like that are sort of about the organizations of lawyers. The rules that start with 6 are about pro bono and public service, and those are not heavily tested, or we're going to cover them very quickly in the course. The rules that start with 7, which were completely overhauled in 2018, pertain to advertising and solicitation by lawyers. And so 7.1 through 7.6 are all about lawyers basically promoting their services or advertising or trying to bring in new clients. And then the rules that start with 8 are a special set of rules about sort of your relationship with the state bar and applying for licensing, practicing law without a license, and reporting misconduct and things like that. So the rules themselves, that's kind of the overall structure of the model rules as a group. When you look at each rule, I want to tell you some things to watch for, because they almost follow like a genre or a template in the way that they're drafted. The first section, which is often lettered A if there's multiple sections. A few rules are just one sentence or one paragraph, but the longer rules or more substantive rules will have subsections within them. And the first section is usually this broad sweeping prohibition or requirement. No lawyer shall do this, or a lawyer must always do this. And then if there's subsections under subsections like A1 and A2, those are qualifiers, and we'll say things like this applies to the extent of this, or maybe a definition. This is the situation, or this is when we're counting someone as as in the category of people that this rule pertains to. When rules have a section B, that's usually the exceptions to the rule. And so now keep that in mind, it's going to be important later on. But so sometimes A will actually refer to, unless the section B applies, and I just want you to recognize up front, that's going to mean the exception section. And so these are things that it's different than a definition section. We're not narrowing the scope of the rule. We're sort of picking out someone that's at there's some sort of special policy reason that we have a different rule in this specific case. And then C, if there are other sections like C or D or E or F, a lot of times those are specific case rules, like special prohibitions or requirements or very specific exceptions. Now, all of the rules have an official comment from the ABA. This should remind you from your previous law school courses of things like the restatement from the American Law Institute that comes with official commentary from the drafters, or if you had a course that used one of the uniform codes from the National Conference of Uniform Statutes, like the Uniform Commercial Code, the UCC, or the Model Penal Code, or something like that. A lot of times they also have official comments that can be pretty persuasive for courts. What you need to know for professional responsibility is the MPRE will absolutely test your knowledge of the comments as if the comments were part of the rules. So there will be questions on your MPRE that are based entirely, like the answer, you have to know some provision that was only in the comments, not in the rules. So you kind of need to study the comments essentially as if they were amendments to the rules. From a testing standpoint, that's how the MPRE is going to look at it. Pay special attention, therefore, in the comments to specific definitions, specific prohibitions or requirements or exceptions that are buried there. Sometimes way down in the comments, it will say something like, of course, this doesn't apply to an LLC or to arbitration agreements or something like that, and make a note out of that, because those are easy to turn into gotcha questions on the MPRE. The other thing you need to pay special attention to in the comments is the example. So occasionally in the comments, it will start a paragraph with for example, or start a sentence with for example, and give a little hypothetical. The MPRE examiners love turning those into multiple choice questions. So if you're a person who prints out things and uses a highlighter, that's something you should highlight, is every single place. In my course, when I'm going through my PowerPoint slides are mostly comprised of the rules and the comments, and I will always take the for example instances in the comments and talk about them in my lectures. Also, keep in mind that some of the comments are just fluff. They merely restate the rule provisions themselves, or declare some sort of broad policy goals of the rule that should have been obvious already. So not all of the comments don't have equal substance. A lot of them are just fluffy, and you're going to have to kind of wade through the ones that are surplusage and find the ones that really functionally are another part of the rule. We're going to start my course with the most important rule, which is 1.7 about conflicts of interest, and it has the most comments by far. Okay, now some comments, but from a testing standpoint, say which rule wins when two specific rules are in tension. Usually this is about the confidentiality rule 1.6, and then the various rules that require disclosures or truthfulness, like candor to the tribunal or not destroying evidence and things like that. So as you can imagine, if we have one big rule, 1.6, about keeping your client's confidences and keeping secrets, and then we have a spattering of other rules that require disclosure or answering questions truthfully on the part of the lawyer, that's going to create hypothetical situations where those two rules are in tension. And the comments are pretty good about telling you which rule wins. The MPRE is bad about testing on that very thing. And so these which rule wins comments are the basis for some of the most difficult questions on the MPRE, and also some of the most difficult ethical quandaries lawyers face in practice. So watch out for that. So when you're reading through the comments to model rules, always watch out for a little phrase like "to the extent permitted by Rule 1.6," which means that Rule 1.6 wins when you get a fact pattern that pits these two rules against each other. Or notwithstanding the requirements of Rule 1.6, which means this other rule wins and prevails or trumps over 1.6. When you're reading the model rules, watch out for four intentionally vague words, and reasonable or reasonably, material, materially as an adverb, substantial and significant, and of course each of these can occur with an ly as the adverb form. You've encountered these, at least some of these, in your first year law courses. So you may remember a whole section of your torts course about the reasonable person standard. And sometimes in a live class, I will ask students, so what is a reasonable person? And I get all sorts of circular definitions, or people fumble around. People talk about what most people would do in the situation, even though courts don't take surveys, or it's not like we put it out to a poll or something. And so watch out for these words. These are kind of hedging words that we put in these statutes. You probably had a section of your contracts course, a whole unit or chapter on substantial performance. And my bet is in that section of your casebook, you had cases back to back. Construction cases are very common, where in one case, the building was almost entirely complete and a court said there was no substantial performance. And in another, the very next case in your casebook, very common in contracts casebooks, the contractor, the builder, had only poured the foundation and amassed the building materials at the building site, and the court said it was substantially completed. And if you were left scratching your head, then you actually understood. And the substantial performance ultimately means the court gets to decide you win and you lose based on the facts. You may not have encountered significant and material. These come up are favorites in administrative law. So vague words like reasonably, materially, and substantially occur very frequently in the model rules of professional conduct, almost every rule. And in practice, these vague terms give a tribunal wider discretion to decide whether a lawyer deserves punishment. In other words, case-by-case decision. So when you see a word like the lawyer reasonably believes, don't ask yourself, like, do I think it's reasonable? The question is, when you get in trouble with the bar and you go to a disciplinary hearing for suspension of your license, or the Board of Law Examiners or something like that when you're applying for a law license, will they think that you were reasonable? And when we put that word in, we basically give discretion to the tribunal. Now, from a testing standpoint, this all actually matters for your life right now, because it's much easier for people who I write test questions. I write them for myself. Sometimes I write them for publishing companies. I have in the past written bar exam questions for some states. And it's much easier to write a multiple choice question about a specific provision, because you can have one right answer and everything else is simply wrong. And what's going to be the most specific parts of the rules? Usually specific provisions, or something very specific like like the requirement that certain documents have to be in writing between the lawyer and the client. It's really difficult or harder to write multiple choice questions about vague provisions like the reasonable lawyer. Why? Because then you have to come up with something, such an extreme hypothetical that any student taking the test will think that this was unreasonable, or everyone taking the test will agree that this was, like almost everyone will see that this was reasonable. So a disproportionate number of your questions on the MPRE and on my exam are going to be about the specific provisions in the model rules and the comments. And when you're studying for the MPRE, you should invest extra time in terms of memorization and studying to things, the more specific they are, because the more specific it is, the more likely you are to see it as a gotcha question on a multiple choice test. Now, what's the legal effect of the ABA's model rules? Why do we care? Now, first of all, remember that these are just model rules like the Model Penal Code or a uniform act like the Uniform Commercial Code. And then what happens is each state adopts its own rules governing lawyers. Almost every state that I know of has adopted big sections of the MPRE, or I'm sorry, not the MPRE, of the Model Rules of Professional Conduct, of these model rules as the basis for its rules, but no state has adopted verbatim all of the rules in their present form. And so when the ABA amends a rule, like it did the advertising rules in 2018, there's a lag time of a few years while states get around to updating their rules, and some of them are going to just go with whatever the ABA has as their verbiage, and some kind of tweak the wording a little bit. They may number their sections slightly differently and so forth. Now, remember, when you're a lawyer, it's the rules of your state that are binding on you and not the model rules themselves. The ABA doesn't license lawyers or bring enforcement actions against anyone for violating the ethical rules. Occasionally, I'll have students in a class early in the semester, they're confused about this, and they'll say something, we'll talk about a rule violation, and they'll say, would the ABA disbar someone for doing such and such? And I want to make sure you understand right up front, the ABA doesn't disbar anyone. They have no legal authority to do that. This is all done by your state disciplinary authority. In some states, that's called the Grievance Committee. In Texas, it's called the Office of Chief Disciplinary Counsel, or the Office of Disciplinary Counsel. It's sort of a subset of the state bar. In some states, this is all, they're going to have a sort of a committee that does it, and then it gets kicked right into court. And so these end up kind of being superior court decisions or Supreme Court decisions and so forth. Now, if some of you may be thinking, so why do I care about the model rules if they're not the rules that I'm going to be bound by in my state? Well, the MPRE tests the model rules, not your state rules. It's good to learn the model rules, because just like in an administrative law course, we usually learn federal administrative law, not your state's administrative law, because every state has kind of based its laws largely on the federal framework for administrative law. And the same is true with the state ethical codes for lawyers. A really good starting point is to know the model rules. And also keep in mind that even if your state has a somewhat different rule than the model rules, differently worded rule, or they haven't adopted a change yet, it's persuasive authority for most state bars and for courts that the ABA has settled on a particular rule. And that concludes our little kind of overview, bird's eye view of the big picture of the model rules.